So are your students competent 21st century researchers? Those of us who teach legal research know that the world of legal resources, like the rest of the legal world, is being disrupted. But the work that lawyers do, whether the final product is a brief or an email, an oral argument or a legal app, that work still doesn't happen without legal research. So many professors and employers believe that millennials are born and bred with technological expertise, and yet they're puzzled when those same millennials don't turn out to be the best summer associates or research assistants. There's something missing in the middle, and what's missing is legal information literacy. You can't conflate ease with using technology with ease with performing legal research. There's something going on there. And we don't actually privilege in law schools teaching legal research as a critical skill that students actually need to be taught in order to solve legal problems. So we now have Westlaw Next, Lexis Advance, Bloomberg, FastCase, CaseMaker, Ravel, CaseText, Google Scholar, and a long list of really valuable online government legal resources. We do not have time in the few hours of research that all law students are given to teach them how to use each and every one of these resources. There's too many, they change, and we don't actually know what our students are going to use or have access to when they're in practice. What we can teach them are the meta skills, how to find the right legal resources for a problem, how to interact with a new search interface, how to evaluate a website, how to know what kinds of searches you should do in certain resources, how in fact to be comfortable with any of today's legal resources and any that come along in the future. Now, current studies of new associates show both that legal research is a highly valued skill in every practice area, and that new associates spend 30 to 50% of their time researching. So, research still matters. And what kind of research are our students doing when they get out of school? Not very much, it turns out. So Scott Moss actually did an empirical study of the relationship between research and writing in legal memoranda and success rates. He looked at summary judgment motions where the same actor inference was raised as a defense to a plaintiff's employment discrimination case in federal district courts. We're going to look at the Southern District of New York. So the same actor inference says that if the person who hired you or promoted you or gave you a raise is the same person you're now saying discriminated against you, you lose. But there are some factual circumstances in the Southern District of New York where you can rebut that inference if you can find the cases. What Scott Moss's studies found was that 72% of the plaintiff's brief in these cases did not cite those rebuttal cases or any relevant legal authority. That's bad. That's very bad. And they lost at very high rates, 80%, 6% of those. I mean, it's amazing to me that any of them won. So we don't want our students to be the ones that do such a lousy job. We do want our students to be the ones that understand they have an ethical obligation to do minimally competent research. So we need to teach them, every one of them, not just how to do good research, but how to deal with a situation where they're young and they don't have access to traditional legal resources, which explains a fair amount of the result in Scott Moss's study. Not all of it, unfortunately. So this is very easy to do, and I'm going to show you how using Scott Moss's example and the demon, Google Scholar. So if you use Google Scholar's case database, let's see if I can make this work. You can pick your court, so positing a lawyer in the Southern District of New York, you can choose just those cases, and if you're a young lawyer facing a case where a defense lawyer says your claim is barred by the same actor inference, this search is free, and it's better than 72% of the plaintiff's lawyers actually did in the study. So the search is same actor inference, employment discrimination, summary judgment. So this is an opportunity to build on your students' familiarity with Google and teach them a few advanced search skills and leverage the knowledge that they can do this no matter where they are or what they're doing now. I know, Google Scholar is not complete. There's a lot of things wrong with it. It doesn't have all the cases. All of the cases aren't actually the final version of the case. It doesn't have unpublished cases. It doesn't have statutes or regulations. But still, some research is better than no research. And you can leverage these kind of searches to teach some broader lessons about legal research, about, in fact, the limits of Google Scholar and the necessity to use certain kinds of searches there. For example, Google Scholar actually has kind of a rough citation checker. So you can get little snippets, a few snippets of how your case is cited, and then there's a list of, let's see if I can do this, of 37 cases that cite your case. In order to know how the court dealt with them, you would have to read them all. So one of the benefits of moving from free resources to paid resources is that your students are a lot more receptive to the idea that those little symbols that say whether or not your case is overruled or treated well are useful and important to know about, and that you could use head notes, for example, if there's 4,000 cases in your result, which happens with research, to limit the ones you look at just to the ones that are really interesting to you. Another lesson that you can use with Google Scholar for your students is to show them that every algorithm is unique. So one of the things I ask my students to do is to take their search and run it through a few databases and compare the results. So here is visual proof that every algorithm is unique. So these are the top 10 cases in Westlaw Next, Lexis Advance, Google Scholar, and Ravel. They're the same search, the same jurisdictional limit, the same actual group of cases in the databases that are being searched by these algorithms. But the results are not the same, although I have to say they were all minimally relevant. So the white cases are unique to each database. Cases that are marked pink are only found in 2 of the databases. The cases that are marked in green are found in 3 of the databases. Not one case in the top 10 cases was found in all 4 of the top 10 results. So this lets you know that every database returns unique results, but not the same results. This is a pretty fair representation of why every algorithm has something important to say about your research, but not the same important things. So using a simple search in Google Scholar to move your students from that search through citators and databases can give them a much more profound understanding of how search engines and algorithms work, a pretty important skill for a 21st century researcher. So what we need to do is we need to make sure that all of our students have an opportunity to learn these kinds of skills. If we continue to denigrate research as a skill, our students are going to be the ones that are so perfunctory about research that they lose. So try and make sure that your students are minimally competent 21st century researchers. Thank you.